So I'm a lawyer. You've got other lawyers around in the room, and I think now is a really important time for lawyers and doctors to be talking with each other, to be working together, because there's some significant issues of freedom of religion and freedom of conscience that we're all facing. One of the things that wasn't on my bio is that another project that I'm involved with in my spare time is trying to start a law school at Trinity Western University. Some of you may... That's actually my latest baby, and I'm very pregnant with a law school. But it's going to take divine intervention for it to be birthed. So I was actually sitting in on our court case in Ontario. We have more in common. We have judicial review applications going forward in Ontario against professional associations. And our hearing was last week in Toronto. It was a panel of 3 judges. Very hard to know where they're going to come out on it. One judge was quite favorable to our position. One was clearly opposed, aggressively opposed, and the third one is happily sitting on the fence there. So we're expecting a decision in 3 to 6 months, and I think that decision will give us some indication of where Ontario courts might land on some of these issues. But I thought I would start off by framing things in a biblical framework. So I titled this, Give to God What is God's, and Caesar What is Caesar. And this is based on, and I mean, I just picked the one from Mark, this story of the Pharisees questioning and trying to trap Jesus is in all of the synoptic gospels, where the Pharisees thought they had Jesus. This is just the perfect question. Whatever he answers, somebody's going to be mad at him. So they're going to try and trap him. But Jesus says, why are you trying to trap me? Because, we know, if Jesus had responded to this question that the Pharisees asked him about, is it right to pay the imperial tax or not? Should we pay it or shouldn't we pay it? Well, if he says pay the tax, then all the people will stop following him because they thought he was going to overthrow the Roman oppressors. And of course, if he says that they shouldn't pay the tax, then the Romans, he's treasonous. They've got him either way. So what does Jesus say? He says, well, bring me a denarius and let me look at it. Whose image is this? Whose inscription? And the Pharisees have no choice but to respond, Caesar's. And Jesus says, give back to Caesar what is Caesar's, and to God what is God's. But then we have the great question. Here's the picture of the denarius. With Caesar's picture, you could actually pick several different denarii when you go on to a Google image search, because each Caesar had his own coin. But then the question is, what is God's and what is Caesar's? We are living in a society where our state wants to take ever more under its wing, and more the state would like more to be the state's and less to be God's. But when Jesus is asked the question, what is the greatest commandment? He quotes back from Deuteronomy. Love the Lord your God with all your heart and with all your soul and with all your strength and with all your mind, and love your neighbor as yourself. So for those of us who are Christians, that's what belongs to God. So we can have that clearly in our minds and hearts when we come to issues of conscience. That is what belongs to God. Well, where do conscience issues come up? Goodness gracious, and an ever-growing area of issues. And you could probably add to this list. I added to it actually this morning, so we might add more to this. Prescribing birth control, sterilization, prescribing or dispensing abortifacients, a whole host of issues with respect to in vitro fertilization, a whole host of issues around abortion. Now we have physician-assisted suicide and euthanasia. I was just reading Stephen Fletcher's recent piece from, I think it was Thursday, where he is very clearly saying the courts have said this is going to be so. And so you'll notice the word physician in the assisted suicide part. And the Supreme Court of Canada used the words physician-assisted death. So that is another issue. And then this issue of counterproductive or unnecessary treatment. And that is kind of a catch-all that I included for a number of different things. We have transgendered issues that are there on the horizon. And one of the more recent newspaper articles or media articles was on a 7-year-old who is presenting as transgendered. And if that young a person presents him or herself in your office for treatment for transgendered issues. Medical marijuana. We've just had another recent case on that, and there are increasing rights being put forward. And when there are rights, what are going to be the responsibilities for those who are providing treatment, healthcare treatment? So that last issue can cover a whole growing area of things. And the legal landscape becomes very important because as the Supreme Court of Canada starts declaring more and more things as rights, and they involve healthcare issues, that involves you. So, 1988, the Morgentaler decision, not a right to abortion, but it has been interpreted that way. It, for all intents and purposes, struck down the abortion law, so we don't have any law on abortion in Canada. The Rodriguez case in 1993, which held the line on physician-assisted suicide, now been overturned by Carter versus Canada in 2015. Sawatsky and Riverview Healthcare Health Center is an interesting case because it is one in a line of cases about the requirement for treatment or health care to a patient. And I mean, there are a whole host of interesting issues there. Well, I'm going to get into this more a little bit in the workshop where Mr. Sawatsky's family wished him to continue to receive treatment, and his physician had put a DNR order on his file. And the court said that the family's wishes in this as substitute decision makers took priority over what the physicians felt was appropriate in the circumstance. So that comes into kind of the conscience issue in providing unnecessary treatment. There have been some follow-up cases on that, kind of holding that a similar line. The Assisted Human Reproduction Act in 2004, the federal parliament tried to provide some good guidance on where IVF rules and regulations went, and it hasn't been very well applied, I don't think, but it does, partly because IVF continues to evolve at a very rapid rate, but that raises a whole host of issues out there in terms of regulation on IVF. The Quebec end-of-life care legislation in 2014, which provided one legal framework for what is now, I think, going to end up being called physician-assisted death, which I think is going to be sort of the tsunami of the Carter case, I think, is going to make that probably obsolete. And then the Carter case earlier this year, which gave the federal government 1 year to come up with a framework for regulating physician-assisted death, and if they don't, the provinces can, or whatever the court said is going to take priority. And of course, we've got a federal election this fall, so the federal government is not going to be able to deal with this in their allotted time. So there have been various initiatives to try to extend that time, but we'll see what ends up happening over that. And then I just put in the Smith case that was decided on Thursday on medical marijuana, and that the court has now taken upon itself not regulating, but approving for medical use pharmaceuticals without any particular guidance to any of you as to what proper dosages are. Look those up in your manual, right? So now there's not just, you can't just, it's not just dried leaves anymore. It's a whole host of how many cookies are you going to prescribe for whatever treatment your patients may need. So you guys know this guy had 200 cookies, marijuana cookies, in his apartment for medicinal use. So, I mean, it literally is cookies that we're talking about here. Okay, so what do we have in terms of the other side? What do we have in terms of protection for conscience rights in Canada? The Charter came into effect in 1982, and Section 2A sets out fundamental freedoms, which is, interesting wording. It seems to imply that these aren't rights, they're freedoms, they're things that are already there. So they're sort of seemingly somewhat immutable things. And A in that is freedom of conscience and religion. Conscience has not really had a lot of attention. It's more been freedom of religion, and most of the people who have claimed conscience rights, it is on the basis of their religious beliefs. So it has, the interpretation has largely been about religion. So, Big M Drug Mart, an Alberta case. As far as I can tell, Big M Drug Mart's not around anymore. Any Albertans want to tell me something different? Still a Big M Drug Mart? Okay. Well, Big M Drug Mart was a drugstore chain that wanted to be open on a Sunday, and this was the first case to get to the Supreme Court of Canada on freedom of religion. Big M Drug Mart, obviously, is not a religious entity. And so the first case to come before the Supreme Court of Canada on freedom of religion, there weren't actually any religious people involved in the case at all. The Supreme Court at that time had very narrow intervener rules, so there weren't any religious interveners. That said, I think the Supreme Court did a pretty good job of setting the basic framework for what freedom of religion means. Now, this is a very nice long quotation here. There's actually a bunch of, those of us who work in this area quote from, we actually just call it Big M. From the Big M case, there are a number of major quotations we have from it that we like to use. It's got good stuff in it. And this whole aspect of freedom from coercion or constraint is quite important. So just this one little, I'll summarize the one little bit in yellow here. One of the major purposes of the Charter is to protect within reason, from compulsion or constraint, which means that you should not be compelled to do things against your conscience. This is foundational, I think, for everything else that we're going to talk about. And the question is always, what is within reason? When can the state coerce you into doing certain things? Down at the very bottom, no one is to be forced to act in a way contrary to his beliefs or his conscience. Now, what is reasonable? When is it that the state can limit your freedom of conscience or freedom of religion? Well, the Charter has this one clause at the very beginning called Section 1. It's our limitation clause. And it actually doesn't matter anymore what that limitation clause says, because the courts never look at it. They use what they call the Oakes test. Now, they call it the Oakes test from a legal case, R and Oakes. It was a criminal law case, and the accused's last name was Oakes. So he now is, I don't even know who Oakes is. You sometimes wonder, who is this guy who gets this test named after him that is in every single charter case? Because every single charter case does this analysis of if the state violates your rights, can it be what we call saved by the Oakes test? And the Oakes test really determines if the government has a legitimate reason and have they done it in an appropriate way that they can limit your rights. So here's generally what the Oakes test, how they apply it. So let's just take the situation of the case going forward against the College of Physicians and Surgeons in Ontario, if they are found to have violated conscience rights of physicians, can it be saved? So the first branch of this test asks if there is a pressing and substantial objective. So can the College of Physicians and Surgeons say, look, we have to protect women's so-called right to abortion. I say so-called right because that's not really what Morgentaler said, but that's how everybody has interpreted it lately. So is that a pressing and substantial objective that they can say, this is so important that we can violate conscience rights? And if they prove that first part, then we go to part 2, which says that the means that they have used must be proportional to that objective. So then there's 3 little parts to that. And all of the little terms that I've put in italics here all have huge amounts of legal definition. These are not ordinary words. These are legal terms now. So the means must be rationally connected to the objective. So let's sort of think about this. Just want to apply it so you understand how it's used. So let's say the College of Physicians and Surgeons say women have a right to an abortion and they must be able to get that. Okay, that's a pressing and substantial objective that women be able to have abortions in a timely manner. Is it proportional to say, okay, therefore every physician must be required to perform abortions? My argument is that doesn't seem proportional. I mean, they would have to have some serious evidence showing that women are not able to get abortions because there's so many doctors with religious objections. I think that's going to be really hard to prove. Secondly, there must be minimal impairment of rights. Okay, is there some other system that they can devise that is going to impair your rights less? Well, I don't think they can really show that there is a presenting problem. Rights of conscience have been protected up until this point, and there isn't hasn't been shown to be an enormous problem in Ontario. So what changed? Why can't we go back to that system? And the third part of this is a proportionality between whoever uses these words, but the courts, salutary and deleterious effects. Okay, here's salutary and here's deleterious, and they sort of balance it through. Now, the reality is that when the courts are looking at this and they want to find things in a certain way, this language is broad enough that there's a lot of discretion on the parts of courts. But you can see that there's a lot of hoops that any government body has to jump through if they are going to have a blanket prohibition on conscience rights in any particular setting. So let's come back to you here. You all have professional designations, as do I, as do many others in society. There are lots of professional bodies out there, and we all have codes of ethics that we have to live by. We also must understand the values of the profession that we are following, and there are also principles of practice that you're under. And you're well aware of that. You're much better aware of that for your profession. I of course am aware of it from my profession, and I'm aware of where the friction points are in that. You're also aware that Saskatchewan and Ontario have been in the process of changing their policies. Interestingly, they don't seem to be doing it in terms of changing the code of ethics. They're actually changing things through specific policy designations. Ontario has already changed. Saskatchewan is kind of in negotiations, but I think you're also aware that other provinces are under pressure to do this. And there are people who have been working to try to change policies at all of the colleges of physicians and surgeons in the country. I had a good conversation last week with some doctors from Manitoba. This is coming up there. I'm sure it is going to come up everywhere. This is really a campaign to limit conscience rights in the area of abortion and potentially physician-assisted suicide. I think probably most of you are also aware of the change in the UBC graduation. Oath, yes. No, you're not? Oh. It didn't happen? Okay, but there was a potential change that they could do, should they wish.
No, the students run that whole thing. The class votes on what version of the so-called code they want to use.
Okay. But I think you can see that there are pressure points that are coming through the medical schools, that are coming through the colleges of physicians and surgeons, and they're out there in certain flashpoint areas now, but they have broader implications. I say this about Trinity Western University. If the state can start telling one university, one Christian organization, what you can and cannot believe and what you can and cannot teach, it actually applies much more broadly. So if colleges of physicians and surgeons can limit your conscience rights in one area, they can start limiting it in other areas as well over time as different issues come up. So what are the laws on conscience rights in Canada? Well, we have a long history of issues in the military. And while my last name is Buckingham, I wasn't born a Buckingham, I was born an Epp. And for those of you who are from Menno areas, yes, that is a Mennonite name. And so conscience rights in the military are something that has been in my mindset from a very early age. And back as early as 1793, conscientious objection to military service was recognized for Quakers, Mennonists, as we apparently were at that time, and Tunkers, which are, I believe, Brethren in Christ, used to be called Tunkers for some reason. The Hutterites and Doukhobors have been added to that. So we have sort of what are now known as the historic peace churches, and those are churches and denominations that have a long history and tradition and deeply held conscientious objection to participating in military service. This was a huge issue during the First World War, and members of these pacifist denominations were granted exemptions from military service for the most part. But other pacifist Christians had a lot more difficulty with that, and there were some who were jailed throughout the war for that. The Second World War was much more challenging, and the historic peace churches did work to develop a whole system of alternative service. But there still were individuals and denominations that had challenges. The biggest one being Jehovah's Witnesses. Jehovah's Witnesses are also pacifist, but they actually became a banned organization during the Second World War, and it was illegal to be a Jehovah's Witness during that time. So I don't want to make out as though this has been an easy issue. It has been a very challenging issue, and Canada hasn't always done well on that particular issue. Now, all of this happened before the Charter. So this is all history and tradition of recognizing conscientious objection to participating in military service that predates our actual constitutionalization of rights. But I think that because there is this tradition and an understanding of this kind of conscientious objection that has been recognized, there's a whole, sort of series of documents out there in our laws that recognize conscientious objection in this setting. This is something that we can draw on because people have an understanding. When I say, Mennonites, people understand, oh, you're people who generally don't participate in military service. And so an analogy can be drawn there that I think helps people understand conscientious objection in other settings. Well, conscientious objection has also been recognized in employment law. There have been a number of different places. Now, every province has some kind of human rights code, and these employment decisions have been made under human rights codes and through human rights tribunals. There's sort of some people don't have a lot of respect for human rights tribunals. People have felt that they don't make fair decisions in certain cases. There's a whole book about that if you like reading by people like Mark Stein and Ezra Levant. So, but I have given you 3 examples of where conscientious objection has been recognized. One was Pentecostal hospital clerk who was asked to sell tickets to an event where alcohol would be consumed. and she was a teetotaler and objected to be required to sell tickets to an event where alcohol would be served. And she was disciplined for that and objected to it through the human rights system, and said that that was a legitimate objection. Someone working at Shoppers Drug Mart who was a Jehovah's Witness. Jehovah's Witnesses do not observe any holidays. It's a matter of conscientious objection to them. They don't observe birthdays, Christmas, Easter, any of those. And he objected to arranging a Christmas display of poinsettias, which most of us who do observe Christmas don't consider poinsettias integral to any religious observance. But the Human Rights Tribunal said he had a right to conscientious objection in that particular context. So I'm pointing these out because it shows how far things go to protect conscience rights in certain settings. And the final one was objection to, these were people who worked for Highway 407, which is a toll road in Toronto, just north of Toronto. And to enter and exit the building, there was a biometric scanner, that looks at, I think, your iris and your fingerprint. And a group of Christians that worked there objected to that, feeling that it was potentially something, related to Revelation and, the mark of the beast. I'm not exactly sure. But they had a very deeply held religious belief that they should not be using the biometric scanner, and they said, then fine, you don't have to work here. And so they got fired from their jobs, and they were found to have a legitimate religious objection to that. Now, religious objections haven't always been upheld, and so Hutterites in Wilson Colony, Alberta, were denied an exemption from the required photograph on a driver's license, which is a very similar issue to the biometric scanner, except that this was in a different context. This wasn't through the human rights system, and this went all the way to the Supreme Court of Canada. A business owner that had a printing business in Toronto, Scott Brocky, was only granted a partial exemption to producing materials for the Gay and Lesbian Archives, an organization that he felt promoted the gay lifestyle, and he objected to producing material for them. And the court said, you have to produce things like stationery for them. If they're producing actual promotional materials for their organization, you could get an exemption for that. And finally, marriage commissioners solemnizing civil marriages. In Saskatchewan, one of the marriage commissioners brought a complaint to the Human Rights Commission, the Human Rights Tribunal, saying that he should have an exemption from solemnizing same-sex marriages because he had a religious objection to it, and he did not win that case. And then when the Saskatchewan government wanted to have legislation to protect civil marriage commissioners, they sent that on a reference to the Saskatchewan Court of Appeal, which said no, on the basis that they were somehow representing the state in their role as marriage commissioners, and therefore they could not discriminate against same-sex couples. So we have kind of things going both ways on that. Conscience rights specifically in the medical situation have generally settled. So we don't have a lot of kind of precedence on this issue. So here in Alberta, a pharmacist negotiated a right to refused to dispense birth control. In Ontario, just north of Toronto in Stouffville, nurses who objected to participating in abortions were accommodated in that setting. It took 6 years, but they finally came to an agreement on that. And then in Ottawa, there were doctors who were facing some disciplinary action for refusing to prescribe birth control for unmarried patients. So what we end up with is competing rights. And on the one hand, you have conscience rights of physicians, and on the other side, you have the right to non-discriminatory medical treatment for patients. And so what you end up with is courts having to balance between these rights. So courts have dealt with quite a number of situations dealing with the balancing of competing rights. One of the early cases was my university's previous Supreme Court of Canada precedent on this, decided in 2001, where the court said that the first thing that any body should try to do in dealing with competing rights is try to delineate both rights to minimize or eliminate the conflict. Can you find a way of protecting, maximizing protection of both sets of rights? In a recent case called NS, you probably would know this case better as the niqab case. It's a woman who accused a couple of family members of having raped her. And so when it came to testify in court, she wanted to wear a full face veil. So she wanted to wear a niqab. Well, there's a right in our charter in section 11 of a right to a fair trial. And part of that fair trial has always been considered to be seeing the face of someone when they're testifying, that you can tell whether they're lying or not by looking at their face. So this was a question about whether she should be allowed to wear her niqab, but the accused would potentially have their right to a fair trial compromised. In that situation, the court set out a formula that should be gone through, the first step of which is this sort of delineate, is there really a problem, is there really a conflict here, or can we find a way of delineating the rights so that there is no conflict? And ultimately ending up saying, you know, that the court, if there is a genuine conflict, they're gonna have to decide between the two rights. And then a little bit more recently, the Whatcott case. Mr. Whatcott passes out pamphlets on abortion and LGBT rights issues. And the balancing had to do with the balance between freedom of expression and the rights of others to be free from hatred. And again, the courts really came out strongly saying you need to try to balance these rights to maximize protection for freedom of religion and freedom of expression. These are very important rights in our society. But it is one of the most challenging areas of the law that courts are grappling with right now. So coming back full circle, what's God's and what's Caesar's? That's where we come out kind of trying to balance between what is God's and what is Caesar's. Your conscience is God's. And how much of your medical practice is Caesar's? How much of it belongs to the state? We live in a rights-based society, and as soon as our Supreme Court of Canada or even some lower courts say that something is a right, there is a corresponding obligation on somebody to meet that right. And the question is, when there are others in society who are willing to meet that need, does the state have the right to force those who are unwilling, to coerce them to violating their conscience? So I'm also doing a workshop at 11:30 where I'll be talking a little bit more about, strategies. But I would be happy in our Q&A session. This is just, here's my book. It's a lot thicker than I can get through in half an hour. So there's a lot more knowledge up here and in here that I'm willing to convey. And if there's other issues you want to deal with, I'm happy to pick that up in the Q&A. Thank you.